Welcome everyone to the session 9.1. This is the session that for the very first time merges lawyers and scientists to talk about restoration at the SERE conference. Our names are Francesca. My name is Francesca Leucci. I'm a lecturer in environmental law at Wageningen University. And
I'm Eleonora Ciscato. I'm a postdoc researcher at the University of Milan.
So this session, for your information, is split in two parts. The first part will discuss the legal challenges in the implementation of the nature restoration law. And the second part, after the lunch break, will discuss the technical challenges in the implementation of the law. So the first question is, why a session with lawyers with legal challenges in a scientific conference? So the idea for this session started at the end of the last conference of SERE in Alicante, where we had a session on the policy implications related to restoration. And we noticed that we needed more dialogue, we needed more collaboration between lawyers and scientists. So the idea finally was developed in the last 2 years, and today we hope to start a successful collaboration between lawyers and scientists, which will hopefully achieve or foster the achievement of our shared goal, which is restoring the ecosystems. So we leave the floor to our first speaker, Anne Cliquet, from Ghent University. And after the next 2 presentations, we will have already a Q&A. So enjoy this session.
Okay, good morning, my turn. When I was writing my abstract for this conference, I had absolutely no idea if the nature restoration law was going to be approved or not. But I thought that, well, we have to upscale restoration, so one way or another we will have to do something about the legal aspects of restoration. So I thought, well, one way or another the nature restoration law will be back. So hence my title. Now, it was quite unexpected, the final approval of the law, and it took a long process, and we already saw this in the plenary session this morning, starting from the biodiversity strategy with all steps in between up to the final adoption in June 24. So, and it was ultimately thanks to the courage of one person that the law got approved, and was mentioned also this morning already in the plenary session, the Austrian Minister for the Environment, who had the courage to change the position for Austria and vote in favor of the law, and thereby obtaining the majority of the member states that was required. So as far as I am concerned, I consider Minister Quessler as the Linda Hamilton, also known as Sarah Connor, of the nature restoration law. Now, maybe also good to know is that because of her action, there is now an action of annulment against for the EU court started by the Austrian government. If you have questions about it, we can maybe keep it for the question time. I don't have time to go into details on that possible outcome yet. Now, we were, of course, all glad that the nature restoration law was approved, but unfortunately it has also been weakened. It is adopted, but it has been weakened. And during the different steps of the process of adoption, there were the changes by the Council, but also by the European Parliament, and those really weakened the original Commission proposal, even leading to quite an absurd text by the European Parliament. Luckily, in the compromise text, that's the finally adopted text, the text is closer to the original proposal by the Commission, but it is still weakened. And as has been said already this morning, it has been published and it entered into force the 18th of August of this year. We got already quite an elaborate presentation on the contents of the law, so I'm not going into details on this. Maybe just again showing you the structure of the law. We've got a very, very lengthy preamble, and we're used to lengthy text as lawyers, but this one is especially lengthy. We've got 91 recitals in the preamble, which for the non-lawyers amongst you, this is not legally binding. Then we've got the general provisions. I think the heart of the law are the restoration targets and obligations. And then we've got the implementation by the national restoration plans. A couple of articles have been added in the final version, thinking about additional exceptions for renewable energy and national defense, for which I'm a bit skeptical. I don't think they were really necessary, but they have been added. There was another one, planting the 3 billion trees. Couple of other things that were added, but also things that were removed. For instance, there was an article on access to justice, and this one has been deleted in the final version. So it moves on. We've got lengthy provisions on monitoring and reporting, and also some final provisions. And also here, we've got something that was added in the final texts, a temporary suspension for the provisions on restoration of agricultural ecosystems, which is kind of surprising, which, as far as I know, has never been seen before in environmental legislation. So it gives the possibility to temporarily suspend the obligations on restoration of agricultural system under certain conditions. I think it's a dangerous path to go by. But well, we'll have to see. What are the most important features for me as a lawyer of the law? It was already mentioned also by Florian this morning. It's a regulation, so it doesn't need to be transposed into national law. So we save time. Usually that takes 2 years or more. So it's in light of the urgency, that's important. We also have got definitions of key terms, restoration, good condition, and so on. We've got, of course, the targets and the deadlines is also very important. We've got also for ecosystems like urban and agricultural ecosystems, we have targets now that we've never seen before in any other legislation. We've got, of course, the detailed requirements on the national plans and also the requirements on monitoring and reporting. Now, the next steps, as you also heard this morning, are the national restoration plans. I'm not going into further detail because Alexandra after me will talk more about the national plans. Okay, so that's where we are now. We have the law, but now, of course, the real work starts. And the proof of the pudding is in the eating. The national restoration plans will make this restoration law a success or not. And it all depends on the ambition that we will have in these restoration plans. And that's, of course, where the role of scientists and lawyers, and with scientists I mean ecologists, but I also mean economists, psychologists, social scientists, political scientists, will have to play their role, as was already also mentioned by Florian this morning. Now, of course, as an environmental lawyer, I will talk a little bit more on the role that lawyers can play in the implementation process. And therefore, I would like to, it was also mentioned this morning in one of the questions, we have a legal working group under SERE. We were established in December 22. And we consist of about 20 experts on biodiversity and restoration law from several European countries, EU countries, including Belgium, the Netherlands, Portugal, Italy, Austria, and so on. So, of course, the first work that we had to do, and not coincidentally, was work on the nature restoration law proposal. And we produced several documents, and our first document we produced was a legal assessment of some of the provisions that we found very interesting or the most important ones. But then soon after that, our really legal work, we had to start responding to the claims or the concerns that were raised on this law proposal, that it would lead to legal uncertainty, that it would, there were all kinds of claims that were made on this law. And so we started producing documents to have a bit of a counterbalance and also to come up with the real legal answers that we could find in the text themselves, or based on our expertise, or based on other legislation. So that were other documents that we produced, and we really also started to, the more false information there came on this law, with the most absurd things that were said about this law and that appeared in the media, the more we started to try to debunk also this false information. Then, of course, there were specific groups that were really making statements that were not true, so we also tried to answer specifically on those statements that were made. And then, of course, the further negotiations went on, and we were concerned on the way that the negotiations were going, so we also tried to respond to these negotiations, and also on the final compromise in the trilogue agreement. And our last note that we produced was when it became very exciting whether or not the law would be approved, we came up with sort of 10 points why we thought we considered that this law really needed to be approved. So, what's next for the lawyers, but I think also for the scientists? There are a couple of legal issues we can examine, first of all, on EU law itself. And the first thing I think we will really need to look into in detail is the final law itself. Like I said, it has been weakened. For instance, the provision on peatlands has been weakened. What does it mean? Also, other provisions that were included that were weakened. We will really have to examine this more closely. Also, we have other legal issues on EU law. We will have to look at key terms in the nature restoration law, for instance, good condition, non-deterioration. For instance, good condition, this is a different term than, for instance, the favorable conservation status that we know from the Habitats Directive. So I think it's also here important to see what kind of differences are there. And this will not just be a legal thing that we will have to examine. It's combined with ecological knowledge that we will have to look at those terms. Ecologists will have to provide and give their input, but we as lawyers will also have to look how is this being interpreted in national laws, in national plans, but also in case law and court cases. Of course, and it was shown also by Florian this morning, the nature restoration law does not stand on its own. It has a relationship with lots of other laws and policies, including, of course, the Habitats and the Birds Directives, of course, also on the Water Framework Directive, and so on. And so we will have to look at how does they relate to one another, also what's the legal added value of the nature restoration law. And then, of course, we also will have to look at other policies, the Common Agricultural Policy, are they in alignment with one another, renewable energy directives and so on, or do they possibly contradict with one another? And then it was also mentioned by Florian this morning, we also will look at the broader picture, not just the EU, but also in a broader context, in the world context. We have the Global Biodiversity Framework. How does it relate to that framework? And also maybe can, because we still think the nature restoration law is a fantastic piece of work. So how can it maybe serve as a model law for other jurisdictions in the world? And I know my colleagues from other parts of the world, they're really looking very much with big eyes to this nature restoration law. Not only at the law itself, but also at the whole process, how it came into existence. So they're very curious and maybe want to see how this could be translated into their jurisdiction. Of course, we will have the implementation. We'll also have legal issues there. What is the ambition level? What are institutional opportunities? Also financing and so on. And this could lead to maybe a form of guidelines as output, or maybe sort of the development of standards and so on. Of course, implementation will also have pure legal issues that we will have examined. What are the opportunities, legal opportunities, but also hurdles? And I'm thinking, for instance, on property rights that could really sort of block restoration projects, but also maybe try to look for innovative legal means to upscale restoration. We'll also have to look at the relationship with permits to do restoration projects, but also permits for other stakeholders. Will their permits be stopped, and so on. And also the non-deterioration clause, which raised a lot of concern among stakeholders. We will have to look at how can we implement this in full. And finally, also, of course, for lawyers, enforcement is always an important part. How we will deal with the access to justice now that it's been removed from the nature restoration law. But also, what can we learn from existing court cases? And how can we learn at EU level, at the national court cases? And of course, there will also probably be court cases on the nature restoration law. How will we deal with those? And maybe we also, if we see that there is a lack of ambition in the national restoration plans, I think we can already start thinking on doing court cases for the lack of ambition. And there I would like to draw the parallel with climate litigation cases, which you know probably of. We could maybe do something similar for restoration. So this comes to my conclusion with a very hopeful message. We changed the past by deteriorating nature, well, I hope we can change the future by restoring it. Thank you for your attention.
We now move to the second presenter, Alexandra Ragau from Coimbra University.
Thank you very much. So it's a pleasure to be here and to speak after Anne. I will now focus on the moment that we are in. We are in the moment precisely after the entry into force of the Nature Restoration Law. And so it is now up to the member states to prepare their national restoration plans. And I am very curious, and I imagine that you are as well, whether this will be a cooperative game, cooperative among member states, between member states and the European Union, or if it will be a hide-and-seek game. My presentation will focus on the context. It is not new, this idea of having planning obligations. In other directives, in other legal contexts, the member states are already obliged to prepare national plans that are supposed to implement, so to enforce in the national territory the obligations imposed by the European Union. Each of these plans in different legal contexts, as you can see here, starts from a baseline scenario for waste. It's the tons of waste that are produced, and then we have to reduce a certain percentage of this waste. For Natura 2000, it's also regarding quantity and quality of habitats, species, and so on. In the case of air pollution, there is always also the need to produce plans and reduce emissions, of course. For water quality, there is also the obligation to prepare river basin management plans, and also for greenhouse emission, there are also climate plans which focus on the carbon sources. So there is an obligation to look at the territory, to look at the internal environment, and start from there and prepare a vision which is then made positive by the plan. If that doesn't work, then there are infringement procedures against member states, and unfortunately, or fortunately, depending on the perspective, we have examples of infringement procedures in the European Court of Justice for all these plans in different legal contexts. So the plans have to address different aspects of the member states' obligations towards restoration. So they must, first of all, deal with the time horizon. So when does it apply? For how long will the plan last, or what is the horizon for the plan? With whom shall we prepare the plan? So it is about public participation in the implementation of the plan. What is the goal and what are the indicators of the plan? So how do we want, what do we want to restore and until what level? And finally, how are we going to do that? How are we going to put in practice the restoration? Now, finally, what can we do? What is the content, the measures, the national measures that will be adopted to implement the plan? So planning is a process, a complex process that the member states must follow from now on. So from the entry into force until the first deadline in 2030. So the plans are meant to allow the member states to fulfill their restoration obligations. And there are restoration obligations in the European Nature Restoration Law regarding terrestrial, coastal and freshwater ecosystems, and also regarding marine ecosystems, and specific obligations regarding urban areas, regarding agricultural areas, and so on, as was explained here by Anne. So what the member states must do from now on is to improve the condition of the habitats, be it terrestrial or marine. So they have to adopt plans that have measures that are effective enough to attain this goal, this objective. And what we will see now is how these plans are produced. So this is to produce sausages, you have to put in the meat. And sometimes we lawyers say that it's better not to know how sausages are made and just see the final part. But we will focus on the procedure of adoption of national restoration plans. So the first moment is the preparation. It is detailed in Article 14 in a very low level of detail, as we will see. Then Article 15 has some hints on the contents of the plans. Article 16 of the regulation has the duty of submission of the plans. When are the member states obliged to submit to the Commission? Article 17 is on the assessment by the European Commission. For 6 months, the European Commission shall assess all the plans that are submitted by the member states. And then specifically in the same article, but number 5, member states are obliged to take into account the observations by the European Commission. So the plans may have to be corrected according to the observations of the European Commission, and the member states are obliged to adapt their plans accordingly. And finally, the plans will be finalized, published, and submitted as final plans. So from all these steps, we will focus only on Article 14, on the preparation of plans, which is the first step of all this procedure. What is established there is that member states should use the best available techniques for monitoring and research, using the latest scientific evidence to produce the plans, take into account the condition and the different habitat types that are present in their territory, and then quantify the area that needs restoration. This is basically what must be done according to Article 14. And we will focus specifically on these two moments: establishing the condition, the current condition of habitat types, and quantifying the area needing restoration. So we will see now how we move from the legal norm to the practice, to the scientific practice. So member states are obliged to establish the current condition of each habitat, then determine what will be the future condition of the same habitat considering climate change, and finally establish the restoration needs to attain the desired restoration result. Transforming this into a schematic presentation, they must map and quantify for each habitat the condition that is known or is to be known by 2030. So in some cases, the condition may not be known, but it is to be known. So this is my visual interpretation of Article 14. So this is the territory of the state. And in the territory of the state, you have in light green the favorable reference area, so the areas that are chosen to be reference points for restoration. Then you have other areas which can be chosen as reference areas, but in the future condition of climate change, in the case that climate change transforms the nature of the area. And then you have all the areas that are not in good condition, number 3. Of course, you must consider as well the areas that are in unknown condition. Those will not count for the obligations, for the restoration obligations. We have to attain a certain amount of restoration obligations. Until 2030, it is 30%, but 30% of what? 30% of degraded areas, and leaving aside, not considering the unknown condition. As you probably know, in other directives, this strategy of saying that we don't know the condition of the habitats or the ecosystems is a strategy that has been used by member states. in their approach to nature restoration or water management. They claim that they don't know the status that it is in. So these are the different deadlines that must be attained. If we move a little further, still in Article 14, in the case that where some widespread habitat types cover more than 3% of the territory, then the obligations are a little lower. As you can see here, it's only 80% until 2050, 53% until 2040, and 26% until 2030, so for widespread habitats. So where is my point, and what do I want to show with this? Why do we have such a complex system? And all these percentages and considering, leaving aside the unknown areas and considering only the degraded areas and so on. It's because until now, we haven't had this sort of micromanagement in the relation between the European Union obligations and the duty to cooperate by the member states. And it hasn't functioned very well until now without micromanagement. If member states are left to their subsidiarity and the duty to cooperate and so on, it's strange, but they sometimes take a sort of a suicidal approach to the protection of their own environment. They are those that should be more interested in protecting their environment, but when we look carefully, they are not. It's a way of trying to hide from the European Union their obligations, trying to pretend that they are doing something, that they are managing river basins, that they are protecting Natura 2000 sites, but in the end of the day, they aren't. So I think that this approach of adopting a regulation which does not require transposition, and it's more effective because it applies directly, and then doing this micromanagement that we see in Article 14, I think it's a good approach to try to avoid this hide-and-seek game, because I think that from now on until the deadline for presenting the plans, we will be playing a hide-and-seek game, and I hope that member states lose and prepare serious plans that can be approved by the European Commission. That's all. Thank you.
So we now have a change in the program because the third presenter unfortunately could not be here, and we will use this time for already to have a Q&A. So I first invite both, Anna and Alexandra to be here. I didn't see you, Anna. And I want to ask from the public, from the audience, if you have already questions about the first two presentations.
I'm here. Thank you for both talks. I have a question for the second presenter. Could you explicit a bit more what you mean with micromanagement and what concretely you would like to see as a change?
Yes. Well, the member states are responsible for their own territory, and therefore we would expect them to be serious, allow me to use the expression, to be serious about what has to be restored and not. And so it would have been enough to say you must restore what is degraded and put it in a good status. But from our previous experience, in other contexts, in other directives, in other environmental aspects that are regulated at the European level, what we see is that member states see environmental protection and duties to restore, for instance, in the liability directive, in the water directive, and so on. We already have duties to restore. They see this as a burden. And this is why they simply try to hide, try to pretend that they are complying with European norms. And this is how I explain this so detailed approach this percentage, this explanation, very, very detailed explanation of how to measure, how to calculate the definitions and so on. I didn't mention the definitions, indeed, but all the definitions and so on, it's not for a matter of linguistics, the fact that Europe is multilingual space. It is because, in fact, member states really don't take it seriously, and this is how I interpret this, and I think it's a good approach, this micromanagement, to see if this time it works.
Sorry, can I just add, but what concretely, you would change? The system is like this now, we have this obligation. Would you want to simplify?
No, not at all, not at all. I'm saying that some people might claim that this is micromanagement, that member states should be left on their own to decide where to restore, when to restore, how to restore, and so on. But the European Union has decided to go a step ahead and say, no, it is important that we control how you restore, where. And so I'm not criticizing this. I'm saying that this is the serious and the correct approach, because member states should cooperate more in the implementation of EU law, and it has been demonstrated throughout history that they don't. So I am praising micromanagement in this case. I'm sorry if I was not clear.
Okay. Other questions? Yeah. Is one? Okay, we have more hands raised.
I'm sorry for asking the same question as in plenary, but I really am interested in your legal perspective. There are countries who are in the process of accession. They're not members yet. And they have their own difficulties, for example, Ukraine, where it interests me. And I am curious, what obligations do they have in the light of accession in relation to the new law on nature restoration? How will it work for them, and what's difference with the member country?
Well, I think once they want to join the EU, but it's a very general answer, they will have to also fulfill all the legal obligations. And usually what is done, but maybe can be contradicted by other lawyers in the room, is that in the procedure before the accession is that they really start already implementing. And I think what we've seen in the past is that sometimes the newer member states, because they were not stuck to legislation that they came up with, really already the good legislation. So it sometimes really works well, but they will be forced to apply all these new rules as well.
And normally when a new member state accesses the European Union, there is a negotiation and a treaty, and in this treaty there are transitional obligations. So there is a period for adaptation, and there can be funding for adaptation. This haven't happened, for instance, in the reunification of Germany, where the Democratic Republic of Germany was the soil was contaminated and the rivers and everything, and then they were given support and a time period for adaptation.
Okay, thank you. We have another question here and another there. Okay. Can you? Oh, okay.
Hi. Andrea Goltari, Italian Center for River Restoration. You said that we should be prepared to go to court and start working on that already for countries that are not ambitious enough. In relation to the 25,000 target, which is not actually a real target in the regulation, how strong is that obligation, since the law says that the country should contribute to the objective, so it's less, it seems weaker. One question, so legally, how we can use that to go to court against our member state, and to what extent we can use the obligation of non-deterioration in relation to current projects for additional damming, for instance, of rivers. Is it strong enough to be successful?
Well, I think that the restoration law certainly provides us with ample opportunities to take it to court. That was also the fear of some of the opponents and some of the stakeholders, that it would give additional possibilities to go to court. And I think because the level of detail for taking the restoration measures is enough detailed that that it will give you opportunities if the national plans are not sufficient. We've seen it in other areas as well. For instance, air quality plans. We've seen there have been many cases for the European Court of Justice because the air quality plans were insufficient and not ambitious enough. So I think if the national plans are not ambitious enough, then it will be able to go to court. If they would maybe in the meanwhile will not start with the process and already you can see from public participation that what they're going to propose is absolutely insufficient, I think also there you could maybe already start doing something. And then of course with non-deterioration, I think we already have the experience with the Habitats Directive and the court cases that appeared both at the European Court but also at national courts based on the non-deterioration provision of Article 6, paragraph 2, which really led to successful cases. And especially in countries like the Netherlands and Belgium, these court cases really led to refusal of permits for farmers and for industries. And that's really an eye-opener. And that's really also what drove a little bit the opposition against the nature restoration law, because they said we're going to have additional crises. We will be stopped in our damaging activities because of additional EU legislation. Would you like to? Yes.
And probably it will be easier to make our point in the national courts because we don't have to look at the national transposition of a European directive and whether the transposition was correct or strong enough. We are looking directly at EU law and implementing it directly because it's a regulation. So maybe the lawyers will have their work facilitated.
Mm-hmm. So there was another question here, the second row.
Yes, please. Thank you. On the subject of the related subjects of micromanagement and the topic that Florian brought up this morning about restoration as an investment, yielding great returns if one accepts a total economic evaluation, I'm struck that both of you seem to be talking as if there was a conflict between sustainable development and landholders and farmers' efforts to do what they know how to do or they want to do on their land, and the law coming from Brussels and the Commission. And to give this a certain spicy flavor in the spirit that I admire so much of your speaking so frankly about the issues, are you suggesting that there is a choice to be made between ecocentric and anthropocentric goals? And if so, how does this correspond to the SER view that there should not be such a dichotomy, that we can answer both objectives?
Well, maybe to give a very brief answer, but then I'll give the floor to Alexandra. For me, there is not this distinction and there's not this opposition. I don't think that we think this is, and indeed we know that restoration is an investment and is not a cost, but it's all the people or lots of groups outside this conference that we have to convince, and they see it as a conflict, and that's where all the false information came on. And I don't think we have to be naive. Also, the Habitat Directive and the Birds Directive were not putting out this conflict, but still we had so many member states who did their job properly, and many stakeholders who were trying or still deteriorating nature in spite of the obligations on conservation and restoration. And I'm not so much in preference of court cases and enforcement. But unfortunately, it's sometimes the only thing that helps, and that's the ultimate solution to make things go faster or make things going.
We as lawyers have seen this film before. Even we as environmental lawyers don't believe in this dichotomy, and we know that ecosystem services will for sure pay off, even in a shorter term than we are thinking. If we think about the nitrogen crisis and so on, there are economic benefits of restoring nature, very obvious, and that will be felt in the short term. But we know and we are sure that many stakeholders, farmers, just to name one, will be trying to oppose the restoration measures, and before that to oppose the restoration plans and so on. And so we must be prepared to face them. And we wouldn't like to think about this as a conflict-generating issue. We would like to see a large consensus on the need to restore, even for economic reasons, because in some cases it is demonstrated that we are having a wrong approach to nature restoration. But well, practice has shown that it will happen. Conflicts will appear, and we will have to demonstrate that it is an investment and not a cost.
Okay, since we are approaching the end of these 15 minutes, I would invite the people with questions to raise your hands. So we have Jordi here, another question, 3, 4. Can you please ask your questions one after the other, and then we leave. We'll hope to have a few minutes just to answer. So all the questions one after the other first.
It's more a comment than a question to James' point. You ask about the role of SERE here. And I say this, I think we can learn a lot from what has happened during these 2 years and avoid this direct conflict as you farmers and we ecologists and so on. So I think SERE can contribute to that in 2 ways at least. One is by strengthening this legal working group and having a crowd of lawyers ready to make sure that the law is well applied. And on the other side, we have a major role to convince people, including farmers, that there's no conflict here, that we are, I mean, nobody could argue that we all want more organic matter in the soil, right? So there are common goals, and we should work in SERE to raise awareness on these sectors and the whole society. And I think that that's an important role for us too.
Thank you. So was comment. Then we have a question there. First here, because there was a question here first.
Yeah, thank you. Yes, of course, is a plan B, the infringement procedures, but would you mind to clarify for the audience what are the consequences for unaffected member states? Are they economically, are they just infringement? We know there are, under the framework of Habitat Directives, many countries that have been infringement procedures, but many of them are there waiting for the final decision. And then if you have time, if you can clarify what is the major force option for them? Thanks.
Thank you. We take the question from there.
I was wondering whether you can shed some more lights on the difference between this good condition and the favorable conservation state. So what is really known to be applied for the good condition as opposed to what we understand is the favorable conservation state?
Just the last question.
Thank you. Good morning. Just a small comment. I spent my life in the Federal Agency for Nature Conservation in Germany. Now, as a retired person, I tried to make restoration and conservation on a local level. The experience that is there, that on the local level, this is referring to your micromanagement. Nobody has ever had any idea about what was going on with the nature conservation law, which is a fantastic thing, but at the moment, as designed in Germany, it will never work unless not the farmers are convinced that they are doing good, but at the moment the farmers are paid for the service they bring for the society in restoration, in restoring the environment and not the habitats. Habitats are far too small. Yeah, it has to be restored at landscape level, and the farmers have to be paid for their service, not subsidized. And all the subsidizing programs of the EU are not sustainable at the end. So this is a small remark.
Thank you. So I invite Anne and Alexandra 1 minute, quick reaction.
Maybe just on one question then, on the enforcement of court rulings, what can happen, if I understood your question correct? Well, at the level of the EU, if a member state does not fulfill its court ruling, the Commission can take the member state again to court, and then it can get fines, and there are serious fines. So that could be an infringement. And on the national level, we've seen it at a very concrete level, where indeed permits are withdrawn and so on, or where projects are not allowed to happen or do not get a permit. So that is also something that really scares stakeholders and also member states.
Regarding the difference between good condition and favorable conservation status, we would I wasn't prepared for this, but I think that we will have to work on this difference depending on the type of habitat that we are talking about. But I would say that from my first interpretation, good condition is not as ambitious in the last version of the restoration law as the favorable conservation status is. So it is less ambitious in my opinion, but we can discuss that later. And regarding paying farmers not to contaminate or to keep the land, I don't know, we could discuss payment for ecosystem services also in other context, because now we don't have time, I think, but it can be discussed.
We can continue the discussion also at the end of the next session, the one on technical challenges. So I invite now the next speaker, Asko Lömus, from Tartu. And yeah, thank you. You have your 12 minutes.
Thank you. So I'm not a lawyer. I'm a sustainability scientist, and good to see so many people speaking so confidently. I'm looking maybe on the same process from the other end, so I'm talking about what might be the outcome. And the outcome, as I tried to say to you from a scientist's perspective, is highly uncertain. So maybe a way to look at this is that restoration was a small-scale enterprise, and now it's going into mainstream. So any uncertainties, any impacts it had on a small scale will now be large-scale. And I think this is the case where we need to reconsider those uncertainties that are in there, and possibly or advisably to organize these as a standards. So where do the uncertainties mostly enter? And I think that there are two main sources. One is that we usually have several options what to do in restoration at various scales. And then even if we know what we are doing, then we may have different predictions of what might happen after that. And so these two things should be somehow harnessed. And what I'm trying to do here, and in very short time, is that I present a typology of 5 classes of main uncertainties. Maybe this is something where to proceed, and these standards do not exist right now. Before I go on, I just recommend some literature. I'm not the first person to deal with this. And there are several good papers, and these are my recommendations for anybody who would like to go into this. There is a good paper on simplified assumptions in restoration. There is the trade-off that when we try to reach local socio-cultural meaning for restoration, we may lose the global importance and the other way around. that there are at least 3 different world views included, so that the same restoration intervention can be seen very differently by different people. And then finally, that this deep ontological problem with restoration is that we are not restoring nature. By definition, the activity makes any ecosystem more artificial. So how to deal with that? Okay, so my starting points for the uncertainties, there are 3 points. First is about possible trajectories, and I think they constitute 3 parts. So the first is simple prediction uncertainty. There is not just one line as trajectory, even if it realizes, but our prediction about that has an increasing error towards future. Then the second thing is that we have deep uncertainties. There can be completely different trajectories, each with their own uncertainties or unpredictabilities. And finally, we also have these different decision options, which further introduce diversity into this, what is the outcome? Then another issue I think is worth looking at is whether we make short-term or long-term predictions. Long-term predictions in many ways are much better. They contain more information. Very short-term predictions are very likely what we currently have and can measure. Also, the long-term predictions can include surprises, events, things that are usually not included in the short-term predictions. So that if you make a pile of short-term predictions, you don't end up with a long-term prediction. This is a different thing. But on the other hand, which is often felt, is that they are less relevant. They are far in the future. They are less certain. So we have to decide the time frame. And finally, I remind this Barry Commoner's rules of ecology. The third rule is nature knows best. In a way, restoration is always challenging this rule, saying that people know better. So this is something to discuss. Okay, so my 5 classes. The first, already touched here, is that there are necessarily alternative post-restoration trajectories, and how many of those we take into account matters in how we rank the options. Let's say and it also matters in how we assess certainties. Let's say somebody may feel that there was a 90% certainty of reaching certain target, and now with intervention we add 10% and it will be 100% that is certain. However, if there were actually other options and other trajectories, this increase may be from 30% to 40%, and this is not the same assessment as to the certainty, and so on. There are many issues here, but my suggestion is that we have some solutions for that. We can understand what are the game changers of the trajectories. We can analyze the worst outcomes, and we can make alternative rankings of the options based on those worst outcomes. Second class is that restoration is often described as a hope for future. This is not the same as the most likely thing that we are going to achieve. The most likely thing is that we are going to achieve some partial recovery. However, when we go for the hope, we immediately overemphasize the benefits of intervention. And this is like a technical thing. Why I know this? Because when you start modeling the processes, then you see it. And in the worst case, it may also end up in reporting, which is cherry-picking of those results which we would like to see, not regarding the whole ecosystem state. So I think it's really worth understanding what are the most likely future states, and specifically when we are told that restoration is for the very long term, then we should also include what is the outcome of non-intervention in the long term, particularly in protected areas. Okay, so, and the third, which is the last in the class of socio-ecological uncertainties, is that we usually obtain knowledge from elsewhere, from different time and so on. So there is this transferability uncertainty. And a very good paper here referred to, please take a look if you haven't, about the diverse trajectories following interventions. So what we can do here is that, of course, we can still reconsider the nature knows best principle. In many ecosystems, there are hints how nature would change this ecosystem when just left alone. And then, of course, building larger projects around smaller experimental systems is a good idea whenever it's feasible. Now, two classes of what I call socio-cultural uncertainties. The first is that we tend to fight for our ideal, our worldview, but there are different worldviews of what nature is. And whenever you go with a discussion on interventions, where I have been repeatedly in, you can understand that people are actually thinking of nature very differently. Here is a picture of a forest we were fighting about. So forest ecologists saw a forest even if it was drained in the 19th century, while wetland ecologists saw as an area potentially growing peat again, and they cared less about the forest. So what we should here not do is to suppress this diversity of views, of cultures included, because in the long term, we don't know what path is the correct one. So it's as with biodiversity. So my recommendation is to start from consensual low-risk projects, if there are. Then we should avoid campaigning for particular solutions. We should rather listening. And then we should link different views with different ecological targets. And the fifth class is even beyond that. Restoration is not alone in the conservation world. And what I think restorationists should consider is that whatever happens in restoration will spill over to the image of conservation thinking, conservation movement by large. So if restoration fails, conservation fails, in a way. And I think specifically we should avoid ethical inconsistencies, and I would highlight the precautionary principle. When we talk about other interventions into nature by development people, by those who deal with production, we require precautionary approaches. We should, at least at the same scale, require precaution also from the restoration interventions. Otherwise, we end up splitting in this on the basis of ethics. So, yeah. So that's basically what I wanted to say in this short time. I think my points were that there are substantial uncertainties in restoration. Some are described, but they are not systematized. I would say that, in my understanding, they can be categorized under 5 main headings. We can elaborate these further. And each of them has distinct mitigation possibilities. And finally, not only that we probably should harness those uncertainties in standards, but it can be done. Thank you.
Okay. So I will ask. I can ask the audience to raise their questions. We don't have enough time, so maybe just a couple of questions. One.
Hello. I'm very happy to see your talk. I found it very inspiring, and the fact that uncertainties are brought up, I think it's really crucial to start talking about restoration, because we got used to uncertainties when we speak, for example, of the pandemics. Everyone knows we don't, there are certain uncertainties there, and we can't avoid them. We shouldn't be going around them, but they should be really put on table from the beginning so that the stakeholders are aware of them and live with them, right? Because they can put restoration into question otherwise. So, and it's just a comment, actually. I also found it really good that you pointed out the importance of listening to different perspectives. Just before the talks we heard, there was this phrase that disturbed me a bit: we have to convince the farmers. Well, we also have to listen to the farmers. They have their reasons, right? And I think there's a big challenge in opening up and starting a dialogue with different stakeholders, because if we just go trying to reinforce and impose, this will be counterproductive, to my opinion. So I'm really happy to have your talk here. Thank you.
Yeah, I'm very happy to hear also this, and I think that it's also a cultural development. We shouldn't find it a problem that we don't have maybe paid this attention on a large scale. We are paying now. And politicians are much better in that, by the way.
Okay, we take another question from here, and then we move to the next speaker.
Thank you. Indeed, a very wonderful presentation on an important subject. Louise Wilmot from the Netherlands. I'm wondering, your final point on your slide, on your concluding slide, was about this might be implemented into protocols and standards. Why did you choose the word might?
That's very easy, because I'm not a lawyer.
No, but okay, maybe let's rephrase this question. So are you already trying to implement uncertainty thinking in, like, working with others who are trying to say something about restoration effectiveness or restoration planning? Are you trying to implement these concepts into the scenario work or the planning work?
Well, I personally have, actually developed those and experienced those at this grassroots level in different projects, maximum at the national level, discussing some issues. But where I'm not confident and where other people should help is this high political level agreement, because we scientists are not actually the professionals of that. But what we can do is we, of course, can describe them in much more detail than in 12 minutes here. And I hope to do that in a very near future.
Okay, thank you, Asko. Thank you very much. Yeah, sorry, because we need to move to the next. But you can keep your question for the end of the next session. Sorry. We now move to the next speaker. This is a paper presented by Morgan Eleanor Harris from University of Roma 3, and the paper is co-authored with Eleonora. So, please.
All right, good. Many of you in the room here have already carried out some excellent studies about the legal issues connected to ecological restoration, some through case studies or through expert surveys or literature reviews, focusing on the recommendations to upscale restoration. However, going through the literature, we noticed that few of these studies have involved the Italian case in particular. Very few experts from Italy were consulted. But Italy is critical for European biodiversity. We have 140 habitat types, an incredible complexity of ecosystems. And along with this ecological complexity, we also have governance complexity. In Italy, the authority over the valorizzazione, the management of environmental resources, is with the regions, who can then spread it out among local territorial entities. The end picture is that each region is different, each region is complex. So our question was, there we go, how does this work? And what sort of legal reforms are needed to ensure that the NRL is not going to be DOA, dead on arrival, when it gets to Italy? So we thought about approaching this question from an empirical point of view, talking to the practitioners who are already carrying out restoration projects in Italy. And so we defined restoration practitioners for the purposes of our study as people who are carrying out projects, people with scientific background, who will contribute to the realization of the targets in the NRL. We recruited participants in various ways, but we tried to get a representative group. We tried to represent where people are working in Italy to get a balanced view of the regions, but also the ecosystem types that they're working with. Some people work in more than one region and more than one ecosystem, so we created a semi-structured interview with questions focused on their personal experiences, when and where they've carried out projects, what sort of relations they've had with public authorities, resources and funding. And we were very careful to word our questions in a way that was neutral, asking not what problems have you had, but how is it going? Because of this, we actually ended up learning a lot about what makes projects work and the facilitators of restoration, which we'll come back to in a minute. So we did qualitative analysis. Today, we're just going to share some of the big overviews of our results. And what we've come up with are 5 big categories of barriers and 4 big categories of facilitators. Good.
Yeah, now we are not going to go too much into the details. That is good for the paper itself. But we want to give you a hint of all of these barriers that we have identified. Well, first of all participants reported having had issues with the lack of expertise and or the lack of interest in restoration on the side of public authorities. Now, this is crucial because they have all mostly worked with public authorities, so it is to the public administration to decide eventually where and how they want to implement restoration projects. And the problem with expertise and interest was twofold. On the one side, because several times they claimed that the professional they were working with had a different background and couldn't really enter into a dialogue with the specific needs of ecological restoration. And the second one was interest. Well, if this is true, it is also true that all of them reported that when a personal relationship was possible, when they managed to get closer contact, then they were also able of influencing more the final decision on what to do and what not to do. Second element is property rights regimes. We have talked about this already. It's a big issue for people working in the legal field, and it is an issue in Italy too. But if we want to scale up restoration, this is something that we cannot really avoid for 2 reasons. One is quantitative. So, for example, in the case of agricultural lands, several experts underlined how very little effort could provide with huge benefits. And the second one is qualitative, because others also suggested that, for example, forestry that is privately owned sometimes has already good quality, so it would be very important to get connection with them. And even though property right it's often highly fragmented, what practitioners told us is that there is a huge opportunity to work, especially when there are collective property right regimes. Third element is bureaucracy. So all of them has had the nightmare of working with complex authorization regimes, procurement rules, concessions, for example. And while they all reported that they face really difficulty in doing that, sometimes this would prevent them from actually starting projects. They also said that sometimes it would be quite easy to revise some of these key procedures that they encounter on a day-to-day basis in light of restoration needs. So that would be somehow an easy way of overcoming this barrier.
All right. Competences, we've already said, is a very complex situation within Italy. The problem arises when there is unclear division of competences. We don't know which is the right authority that we need to contact in order to get a project done in an area. Our restoration practitioners reported that they would avoid projects where they didn't know who had authority over the area, especially in marine restoration. This leads to a concentration of projects within marine protected areas because at least they know who to call. Some of our interviewees suggested that the solution to this complex and unclear division of competences would be to bring authority back up to the central level, take the authority back into the hands of the Ministry of the Environment. But some of the facilitators that we identified arise from the personal and close relationships between practitioners and local authorities. Local authorities and practitioners, when they have social ties, they can spark interest, they can spark trust, they can find new opportunities to work together. So centralization of authority, we think, is probably not the right solution here, but we do need to clarify the division of authority. Where we have multiple authorities involved in a project, of course, conflicts of interest can also arise. Conflicts of interest horizontally or vertically, as well as problems with public opposition. Now, when it comes to conflicts of interest among authorities, one of the key facilitators was the presence of a mediator. When one of the public stakeholders takes on the role of resolving the conflicts with the others, projects, even very complex projects, can move forward. Sometimes mediation can also take place with the practitioners themselves by creating a steering group or by creating informal meetings. So mediation is the key here. Mediation is also the key when it comes to conflicts with the public. Our practitioners overall did not report having big problems with public opposition. If anything, the public wants more restoration. They have unrealistic expectations. But finding the trusted representatives of the communities can help to overcome any opposition that may arise. Most opposition has to do with projects that touch on identity-defying features of a place, or where we have contexts of toxic legacies, where there is a history of degradation, not just of the environment, but of the institutions. That mistrust can have reflex on future restoration projects. So we don't need just to restore nature, we need to restore trust. The last big facilitator that we found had to do with multidisciplinarity. A lot of our practitioners suggested that working on multidisciplinary teams enable them to do more and to do it better. Working not just with other scientists, botanists and entomologists, for example, but working with people from the social sciences or engineering or business or architecture. Especially important for restoration in agricultural areas. But in order to enable multicultural approach or a multidisciplinary approach to restoration, the other disciplines need to be able to understand what is going on. It's not enough for practitioners to be willing to work with engineers if engineers don't speak the language of restoration. So one of our suggestions for legal reform would be to include ecological sciences within non-ecological degree programs, in particular in those professions where, that are going to have contact with restoration over the upcoming years. We also need to reform some of the professional qualifications, in particular for the agrarians and the forestry sector. So we've also attempted to map the causal relationships among these various facilitators and barriers through a network analysis approach. This is a bit of a work in progress, but we can see some things already quite interesting. One, these are facilitators. One of the central facilitators is social networks, those social ties between practitioners and other practitioners or with the public authorities. And one of our biggest barriers is lack of interest, but we're still working on this. We asked our practitioners what their general recommendations would be, how to upscale restoration in Italy. They gave us some ideas, but we have some ideas as well.
Indeed, it was hard to decide which were the key recommendations because there are a lot of things that could be said, and it was really insightful to start this discussion with professionals. But if we have to choose, first of all, improve the enforcement of existing laws. This does have an impact not just on the protection of nature itself, but also on the type of trust that you have, that you can develop through institutions, and we saw that this is really relevant. Second of all, we couldn't stress it enough, cultivate opportunities for building social networks. And this goes in different directions, so between practitioners and public authorities, but also towards other stakeholders and the public in general. A third element that we would like to highlight is the integration of ecological studies into other disciplines and into professional requirements, because then sometimes what a lot of practitioners said is that people who actually can assign projects don't know anything at all about restoration, so this is crucial. And then clarify division of competences, as we said, both horizontally and vertically. It doesn't need to be all centralized, but we need to know who to talk to. And then review funding structures and authorization procedures so that they are informed with what is necessary for restoration. And finally, remove regulatory barriers to increase public-private partnership, because if we want to create what we call an economy of restoration, something that was also discussed earlier this morning, we need to allow people to develop, to create new opportunities. So thank you for your attention. And
yep, we'd be happy to look at the results in more detail later. Yeah.
Thank you. Okay, we have time for a couple of questions. Fastest hands? Okay, I will give the floor here. No.
Hi, thanks a lot for a really nice talk, nice, interesting work. I had a question on your participants, because maybe I was a bit quick, but I saw that they should have at least 26 years of postdoctoral experience. Did I misunderstand?
The average experience was 26 years, so we had some people who were quite close to retirement.
But all of them have doctoral degree? You mean, we're talking about managers, right?
We're talking about practitioners. They all had doctoral degrees except for one.
Okay.
Yeah.
Well, that's great for Italy, having such a very highly qualified managers.
Okay, just a last question from here, please.
Hi, my name is Rachel Christensen, and I'm one of the co-chairs for the NRL Knowledge Hub with Vito over here. And mine's more of a comment than a question, and the same comment I was going to give to Asko with his presentation. These findings from your work are really valuable insights into what we're trying to build with the Knowledge Hub right now. So if you would like to contribute this and we can incorporate it into the work and activities that we're trying to develop, it would be extremely useful. Sure. So your work, Asko, in uncertainties and your findings around that would be fantastic. And also your work here in what you found to be relevant for Italy in this space. So I'd like to invite you to send us an email and your comments and your findings. Thank you.
Okay, sure. Thank you.
Okay, thank you. Apologize for not having the time to take additional questions, but of course we can use the coffee break afterwards, lunch break. So I invite the last speaker, Volker Mauerhofer from Mid-Sweden University.
Yes, thank you very much. I have two challenges. I'm standing between you and your lunch, first. Second, I have only 10 minutes, so including question and answers officially. So let's start. I'm a lawyer, but I'm also a biologist and ecological economist, so I have a little bit of mixture, and I'm struggling with this mixture all my life. So to continue, this is the overview on my presentation. It's going to a plant research, actually, and we have done some pre-studies. It's about our fiber banks, Baltic fiber banks. That's actually an issue. I need those already, this way. So these are fiber-rich sediments which were released by pulp and paper industry a long time ago. Often didn't need even a permit or was permitted long before the directives of the EU came into force. And now there are large toxic substances in the Baltic seas. And, of course, they emit. They emit, they emit, they emit, they still emit. Yeah? So the permit or no permit was necessary before the starting of the EU directives, but disturbances are ongoing. Yeah? And so the question is, what can we do? And that's a colleague of mine who raised the question. He's a natural scientist from restoration. Who is liable for the restoration? We have to bring out this stuff somehow. And there's a common project idea to assess impacts on water, air, soil, biodiversity. the causality for the fiber banks of those impacts, if we can establish causality, and if causality is needed under the directives, and what is the liability, who has to pay, which is often the question in restoration. And of course, we're still searching for possible funding schemes. We had one application. So the European Union, just for those who are not that familiar with the legal framework, and there's some mistake in this slide, as you know, we are 27 now, and there are two procedures. The infringement procedures, which was mentioned by Anne already, that the Commission starts an infringement procedure against the member state. First, judgment by the court. If the member state doesn't react, second judgment of the court, and then payments. There was a case in Austria, I wanted to mention it actually, where the Commission forced Austria, before the second infringement procedure started, really to restore. And there, for example, 2 golf lanes in the habitat of a protected bird, the corncrake, Grex, really has this Latin name because it calls like this, has to be restored, and Austria restored them really, so that's effective in this case. The second one is preliminary procedures, where the court gives interpretations on request of national courts, and those interpretations of the directives or the restoration regulation in the future are binding for all member states. That's the nice thing, yeah? So the case law on the infringement procedure, member states always say, oh, that's only this case. But preliminary rulings, procedures, they are really give binding interpretations for all the member states. So the goals of that research on the fiber banks is to look if already these 3 directives in their current versions are able to establish a liability for those past activities or activities which are set in the past, which did not need a permit or needed a permit and got the permit, and check whether we can establish a restoration duty and a liability already based on them. And that's not only for fiber banks, that's for many projects you might be involved. Yeah? You are confronted with an activity in the past that has effects on your project perhaps, and that activity was even before the directives or the restoration law came into force. So methods, text analysis, interpretation of legal text, case wording historically, contextually. You can read quicker than I speak. 3 main directives now are partly amended in the EU, how they are relating to restoration and damages of soil, water, and biological diversity. So we have these 3 directives, and we have the Environmental Liability Directive, which explicitly mentions soil, water, and biological diversity. Habitats Directive and Birds Directive, in the first view, is more about biological diversity. But if you look more closely, also the soil is important for many plants, and if the soil is affected, those plants and habitat types do not grow into a favorable conservation status. The same for water. Fishes need certain water quality, and some fishes are mentioned in the Habitats Directive. For the Birds Directive, similar, the birds have wetland habitats, marine habitats, and they search often food on soils. So there is a relevance for all 3 soil, water, and biodiversity issues. Now, the timeline issue. We have this impact which is occurred, and we have the ongoing disturbances. And how can we implement this? And there is actually case law out there, and you see the number here of the case. You can find them at the European Union database. So there is a preliminary ruling with a binding interpretation with regard to the liability directive. There was a hydropower plant that was permitted long before the liability directive came into force, but the disturbances are still ongoing. And the court says the directive applies even to damages that occur afterwards. And there was a national law which excluded that actually, and the court said that is not allowed under the national law. Yeah? So we have this effect of the directive on ongoing damages. Yeah? And another ruling also preliminary, and that was really a big chamber of the court. If a plan or project has been authorized under Article 6 of the Habitats Directive under this appropriate assessment, but that plan and project subsequently proved likely to give rise to such deterioration or disturbance, even if there is no error from the authorities, then there is the duty, according to Article 6.2, to prevent such damages. Yeah? So that's also quite strong under the Natura 2000 scheme. EU restoration regulation, I just put here some main questions, started to screen the restoration regulation for the Habitats Directive already. So particularly will be interesting where there are habitat types covered by the EU restoration regulation outside of Natura 2000 and its relation to the Habitats Directive, Birds Directive and Environmental Liability Directive. Which Natura 2000 restoration duties, and there is clearly the duty to restore, and it's quite a strong duty, already apply on them to protect Natura 2000 from outside effects. And I mentioned this today also in my plenary question. The Habitats Directive is effect-oriented. Even if the project has been established outside, it can affect the Natura 2000 side, and you have to assess it. Yeah? And then, particular, the overall question, the interplay between Natura 2000, means Habitats, Birds Directive, and ELD, with the EU restoration regulation. I use regulation because law is not the right title in EU terminology. How far does the EU restoration regulation affect Natura 2000 in legislative terms? Yes. So what is the legislative difference, overlap, synergy, potential contradiction between the EU restoration regulation on one side and the Habitats Directive, Birds Directive and the Environmental Liability Directive on the other side? And what about the implementation then? How do national states apply the restoration law, for example, in the direction of Natura 2000? And how judges, courts on the national level, but also on the EU level, then use those two big blocks, so to say, or those two complementary blocks, so to say. How do they say, what do they establish when it comes on potential synergies or potential contradictions between them? So that will be really big questions ahead. And this is my summary. As I said, you can read quicker than I can speak, so go through it. And yeah, by that, we will have soon an announcement after the Q&As. So please, for the organization up there, prepare the announcement after the Q&As. And I will end with this one, typical Baltic Sea species, of course. And thank you for your attention.
Yeah, we can keep the announcement for later, thank you. Was supposed to be the last slide to present. Okay, so I asked the public, the audience, to raise your questions. Any questions about this last presentation? Or you are too hungry and you want to run immediately? It's the lunch break.
Everybody's hungry and overwhelmed, confused, whatever. Okay, then we do the announcement.
Yeah, okay, so.
So our great announcement is this one. We have a special issue upcoming in the Journal of the Society, so the Restoration Ecology. Editor-in-Chief Stephen Murphy, and the managing editor is also highly involved. Walter. So it's about nature restoration legislation, implementation and enforcement, status, challenges and solutions. The call of abstracts, we hoped for the link today and for the QR code, but it wasn't possible. So it will be out there this week or the next weeks. We are the guest editors, so Francesca, Eleonora, Alexandra and me. And we're looking for research and review papers less than 8,000 words, so be careful there. If you go beyond, there might be charges for extra pages. And we would like also to have natural scientists involved in legal restoration procedures. So we look also forward for papers from natural scientists. And submission deadline is 21st January 2025. And yeah, you're welcome to also contact us if you have questions. And so let's make a great special issue. Any additions from my colleagues?
Yeah, of course, it's not limited to the nature restoration law in the EU, because the special issue will reach out global scholarship. So we are happy to receive papers about the legislation implementation of any type of nature restoration law everywhere. Okay.
And the time is over.
Yeah, so we hope that we started in a good way this collaboration between scientists and lawyers, and the special issue will help us to continue. So let's continue with the next session for the technical challenges, and we also have space and room for discussion at the end of your session, which we can still have an interdisciplinary debate there. So enjoy your lunch break. Thank you.